and welcome back to Military Law Talks. So today I thought it was important to cover a UCMJ offense. That's the Uniform Code of Military Justice. So, a lot went on this weekend, and if you've seen my other videos, I talked about the "What did you do last week?" email that went out. And so I've noticed online there's been a lot of discussion from military officers, active duty, all on social media, so kind of forever, making a lot of comments that are contemptuous towards SecDef Pete Hegseth, the president, President Trump, and other members of his staff. Also because of generals that were fired over the weekend. I did another video on that, and so if you haven't seen those videos, check them out. I'll put the links below. But make sure you watch those videos. So it was a pretty eventful weekend for the DoD. And so I've seen a lot of posts online that might get some people into hot water. So one of the purposes of my channel is to instruct and teach about the military law. And so I'm going to teach today about Article 88. Personally, I've never seen a case with an Article 88 charge that is contempt for officials. But at the end of the video, I'm going to talk about a recent case where this was charged, and that's what I'm going to cover in a later video as well, that case in full detail. So let's explain first about the UCMJ. So for those of you who are not in the military, the Uniform Code of Military Justice is a separate criminal code that the military adheres to. So we have our separate system of justice, a separate criminal code, and we have a separate justice system that's separate and apart from the civilian justice system. And this provides uniformity. So it should be a uniform code. It's the same in all service branches. Now, how we administer justice is a little different among the different service branches, but all the articles are the same. The rules of evidence are the same. And it's very similar to federal criminal law. Particularly, the rules of evidence are very similar to the federal rules of evidence. So our military courts, particularly modern military courts, are very, very similar to federal criminal courts. And so this provides a uniform system, and we also have worldwide jurisdiction. Now, that is because to commit an offense under the UCMJ, it's status-based, not location-based. So in the civilian world, if you commit a crime, it's your location of where you committed that crime is what gives jurisdiction over whatever state or local government to prosecute. And in the military, it's very different. It's status-based. So the UCMJ, the Uniform Code of Military Justice, has jurisdiction over the person. And so any service member on active duty is subject to the UCMJ. And if they commit an offense that violates the UCMJ, they can be held accountable for that offense. Now, there's a range of those, different types of punishment, and we have actually different levels of justice that we can administer. And so, but it doesn't matter where the crime occurred. So we have this worldwide jurisdiction. It's portable. It's the same. I've done court-martials in Hawaii, in Texas, and in Afghanistan, and it's the same process. And we have a long history of a separate code of conduct in the military. Just know that there's a recent U.S. Supreme Court case that discusses this and explains that the military justice system, separate and apart from the civilian criminal justice system, is very old. Ancient Rome had military tribunals, had a separate military system, justice system for its military. The Royal British Navy, or the British military, and that's where we got that idea from. So a lot of our law is based on British law. And in the American system, we actually had court-martials during the Revolutionary War. So our separate military justice system is actually older than the U.S. Constitution, because we had a separate system of justice within the military long before our current Constitution was ratified, a decade or more, right? The Revolutionary War. And why it's important is because it is the commander's tool for good order and discipline, right? We have a military is a very um, driven by commanders. It is a system driven by commanders, and commanders have to have discipline over their troops because we have a unique mission to fight and win our nation's wars, right? And so in order for commanders to ensure that their subordinates are going to listen to their orders, they need to have a tool. We have both carrots and sticks, and the UCMJ is a stick to ensure that those orders are followed. And we have some very military specific crimes in order to help promote that good order and discipline system. So the crime I'm going to talk about today, you won't see this in the civilian system. This is a military specific crime. And this is Article 88 of the UCMJ, and it's contempt towards officials. So this particular UCMJ offense only applies to commissioned officers. So the text of the statute reads, and I'm reading from the statute, Article 88, it says, any commissioned officer who uses contemptuous words against the president, the vice president, Congress, the Secretary of Defense, the Secretary of a military department, the Secretary of Homeland Security, or the governor or legislature of any state, commonwealth, or possession in which he is on duty or present shall be punished as a court-martial may direct. So what does that mean? Let's look at the elements of that offense. So just know that in order to be convicted of this offense, the government would have to prove beyond a reasonable doubt all the elements of this offense. And so there's 4 elements. 1, that the accused was a commissioned officer. So for purposes of this article, enlisted members would not be charged with this article, but Article 89 is disrespect towards a superior officer. So they could be charged with Article 89. But today I'm just focusing on Article 88. That the accused used certain words against an official or legislature named in the article, president, vice president, secretary of defense, etc. And then element 3, that the act of the accused, that by an act of the accused, these words came to the knowledge of a person other than the accused. So it's got to be communicated to someone else. So if it's just your private thought or just your private conversation, that would not be charged, but it has to be communicated to a third person. And then that the words used were contemptuous, either in themselves or by virtue of the circumstances under which the words were used. And so let's break it down even more. So this is straight out of the text of the UCMJ. And so it explains, it just gives a little bit more, and I'm not going to read it all, but to explain that it's immaterial whether the words are used against the official in an official or private capacity. So it doesn't matter if you're in uniform, on duty, or if you're at your house, in civilian clothes, making a post on Facebook. That's immaterial. So remember, the UCMJ applies 24/7. If you are on active duty, if you are on orders, the UCMJ applies. And so it's immaterial whether you're in your official capacity or a private capacity. Also, if it's in the course of like a political discussion and like a private discussion, that wouldn't be subject to this article. If it's like purely an opinion and like a private discussion, those wouldn't be charged. However, if there's broad circulation to either a written publication or words that are published, like on social media, a video that's posted to social media, in particular, right? I've seen several Facebook posts and X posts that likely would meet the elements of this offense. That it was very clear that the person posting was an active duty military officer, and they made very specific, contemptuous, very offensive, in some cases, strongly worded comments directed towards Secretary of Defense Pete Hegseth and the president. So I've seen both. I've seen examples of both. And so just know that if you make these kind of things in a broad public forum, Facebook, social media, that qualifies. And also, or in the presence of military subordinates, and particularly if you have military subordinates who are following you on social media, definitely this is a potential, and that aggravates the offense. So it definitely makes it more likely that you would be investigated and potentially charged with an Article 88 violation. And then that could hold more weight when it comes to sentencing, and know that the truth or falsity of the statement is immaterial. And the maximum punishment could be dismissal, which you lose your commission, you lose your ability to serve in the military. That's sometimes punishment in and of itself. That's sometimes I've seen that for some officers that's the only punishment they got was dismissal when convicted at a court martial, or confinement for up to 1 year. And so, like I said earlier, I've never personally seen this charged in my own personal career. However, there's a recent example of when it was charged. So I'm going to pull this book off of my little thing. So this is Crisis of Command by Stuart Scheller. So I've read this book, and in a later video, I'm going to go over, kind of give a little book review, and then also talk about Stuart Scheller's court martial. So he was actually charged with an Article 88 violation. And so that's a recent example of a military officer being charged with Article 88 for a video that he made right after the debacle of the Afghanistan withdrawal. And he personally called out the Secretary of Defense, superior officers over him, the Commandant of the Marine Corps, in his video, demanding accountability. And he later made several other subsequent posts that kind of dug his hole a little deeper, but he was charged with an Article 88 violation. So in a later video, I'm going to talk about his case and his book, and we'll go over that in greater detail. But just a reminder for all the military officers out here, be aware of Article 88. Again, not charged super frequently, but know that it does exist. And I know you might be thinking, well, what about free speech? Don't I have free speech rights? Well, it's a little more limited when you're a military officer. Remember, Secretary of Defense, the president, they're in your chain of command, and it's important for the integrity of the chain of command, particularly when enlisted soldiers, junior officers are privy to that conversation. It could degrade that chain of command. And so this is a military specific crime. And yeah, military officers in particular have a little less First Amendment rights than the average citizen. And in a later video, I'm going to discuss a court martial from the Vietnam era that was the military officer who was charged for different things that he said while in uniform, directed towards junior enlisted soldiers. He was charged, and he appealed his case all the way to the U.S. Supreme Court on First Amendment grounds. And so I'll explain that case in detail and explain how military members, in a sense, have a little less First Amendment rights because of the integrity of the chain of command and because the unique military justice system that we have. And so we have a unique mission, and so we have unique criminal justice needs to support that mission. So thanks for joining me, and we'll see you in the next video. Thank you for joining me. And if you got any value out of the content, please like, share, and subscribe. I'm a new channel, so please help spread the word. I really appreciate your sharing this message out there. If you have any comments or questions or requests for additional content, please put them in the comments below. Thank you.